Hi everyone, this is Dr. Victoria Naule, and here with me is Dr. Thomas Mweniza, who is a co-director at the Aberdeen Center for Energy, University of Aberdeen. So in today's discussion, we're going to focus on the National Climate Change Acts, and I note that Dr. Mweniza has a new book focused on the same subject. So that will be the main focus for our discussion. But before we start, I'd like Thomas to briefly introduce himself.
Thanks very much. Nice to be with you. Thank you for the invitation. I'm Thomas Munzer. I'm a senior lecturer in energy transition law at the University of Aberdeen, where I co-direct the Aberdeen University Centre for Energy Law, which is a climate and energy focused research institution that does intensive work on legally orientated matters and has a very rich PhD culture and community as well, and is involved in education as well as research. So nice to be with you today.
All right, thank you very much for the introduction. So we shall start with our discussion with respect to the National Climate Change Acts. So could you please give us a brief overview of the subject matter, and also you can give us more information about your book, and then afterwards we shall take in questions from the participants.
Yes, shall I start with the subject matter of the book itself?
Yes, please.
Sure, as opposed to say the UK's Climate Change Act. Yes, well, the book is called National Climate Change Act, the Emergence, Form and Nature of National Framework Climate Legislation. And what it tries to do is provide a first comprehensive research statement on national climate change acts. And it's structured in a particular way. It starts by considering what we actually mean when we talk about a National Climate Change Act, because if you think about it, the climate it's fairly global, isn't it, and pervasive. It could be considered slightly nebulous by a typical legal mind. We're often in law used to dealing with things like kind of hard-edged contracts and things like that. So we get into what we actually mean when we talk about climate change acts. We think about how important they are in the context of national and international law. And the book's a collection that speaks in concert. So I edit the book and I begin the first chapter looking at those issues. Then it moves into a development of those national, international sorts of concerns. Matthias Dewey and Ralph Bodel consider the importance of national framework legislation, national climate change acts, in the context of what we see going on internationally in terms of law. So, you know, with reference to the Paris Agreement, the United Nations Framework Convention on Climate Change, those sorts of things. And then we get into deep dive case studies of national climate change acts. Having set the scene, as it were, in the first two chapters of the book, we move through a series of case studies that select and hone in on particularly interesting national climate change acts and do sort of deep dive analyses. So they begin with a consideration of the UK Climate Change Act, which is really the first climate change act. It came in 2008. And then analysis moves in the next chapter to Mexico's Climate Change Act, which was the first climate change act that was brought in the developing world. Very important, extensive framework. Alina Avrachenkova examines that. We move on through a series of these acts, touching on the Danish Act, Irish Act, and so on. Some of the cutting edge acts that were emerging, the New Zealand Act, and a final fairly substantial chapter ties the book together by kind of reviewing what's been said in the national case study chapters and the learnings from that, considering what's been said in existing literature in this area, which is was prior to the book was fairly underdeveloped, as fairly niche area, although an important area of study and consideration. And it tries to refine how we conceptualize and how we formulate national climate change acts. So by that, we're thinking about how we think about them and approach them, but how we actually formulate them. In other words, what should an optimum national climate change act look like based on the current condition of knowledge and understanding? How might we answer that type of question if we're asked what it should look like? What components should it contain? In what sort of ways should it operate in our complex national environments in our various countries around the world, and so forth? So sort of hard questions, but by then we can point to some generalist solutions. So that's the book, speaks in concert, and as I say, it's an edited collection, not of independent chapters, but chapters that combine to make one overall research statement on this subject.
All right, thank you very much, Thomas, for the brief overview about the book. So let's start with the discussion. Why do we need national climate change acts? And then how effective are they in this era of energy transitions?
Well, that's a good question. Why do we need them? Why do we need them and how effective are they? Let's start with why we need them. It could be argued that in certain national cases, perhaps we don't need them. So if one was adopting that position, one might look at the concrete national circumstances in question in a given country. Of course, when we're dealing with national climate change acts, we're interested in those acts in relation to a particular country that's crafting the act and putting it in place, as opposed to, say, the Paris Agreement, which is internationalist in design. Well, one might take the view that a particular country has quite a sophisticated climate regime in place already. Maybe it doesn't need to have its legislative center of gravity located in a national climate change act. What would a regime of that sort look like? Well, maybe there are other items of legislation that intersect around the issue of climate. Maybe you have some core legislation that is, let's say, moving to decarbonize transport in a particular way. Some other legislation, maybe let's say it's applying an emissions trading scheme to power generation and dealing with that. You might say, well, do we really need this legislative center of gravity within a climate change act? Other countries like to lean on policy quite a bit for various reasons. You know, if you take, say, China, it has a tradition of putting in place extensive 5-year policy plans. And it's not hugely surprising that it's approached climate via sort of extensive 5-year climate policy planning. So perhaps someone in the Chinese Communist Party may suggest that because of China's particular governance tradition, those sorts of nuanced policy approaches are maybe more suitable in that case. So there's probably discussion to be had around those things on a case-by-case basis. But more generally, climate change acts are very useful. Do we need them? I would suggest there is a general need for them. There's an assumption that they're needed and that there's a burden then for a particular country to rebut that assumption. Perhaps it can be suitably rebutted. But why would there be a need for a climate change act? Well, climate change itself is one of the great problems and issues of our day. So we start from a point that it almost goes without saying that countries need to engage with the problem and tackle it. Climate change acts are a useful tool in the toolbox for doing that. And part of the reason is actually implicit within what I just said. It provides a legislative center of gravity, if I can put it like that, for tackling the problem. If you look to a bit of transport legislation here, a bit of green finance legislation there and so forth, you get this real scattered melee of governance that presents itself to you. If you have a coherent framework regime like the Mexican Climate Change Act I mentioned, or any number of examples that are now emerging, you get a sense of coherence. You get typically a sense of long-term legal certainty as certain elements and components are locked into law. So if you took, I'm sure there are many merits in the Chinese context to the Chinese policy approach, but if you take, say, the UK context, which spawned the first Climate Change Act, if you just absorbed all its components into policy can typically be very easily changed and altered at the whims of a government or a new incoming government and so forth. Legislation is typically more locked in by nature. It's harder to deconstruct. Typically, it will involve a necessity for amendments in a national parliament or equivalent national assembly, or perhaps repeal of the legislation. Also, when you lock certain components in law, they typically accrue legal enforceability. They'll be recognized by the courts and others as having a legally enforceable quality. Policy doesn't provide that beneficial aspect in legal terms by definition. So why do we need them? They provide coherence. They provide a legislative center of gravity. They allow us to lock certain important things into our governance regimes nationally in a legally binding way, which can be very important. They provide other benefits as well: certainty, long-term stability. And in fact, just as an interesting point, one of the reasons that the UK's Climate Change Act, which came in 2008 and imposed fairly rigorous long-term legally binding emissions reductions, one of the reasons that act at the bill stage, of course it exists as a bill before it's passed as legislation where it then becomes an act. One of the reasons at the bill stage, it attracted, not across the board, but a reasonably substantial measure of support from the business community and the investor community, was that elements of that community looked at the bill and thought, look, we're not sure what's going to come in here, what changes are going to occur, how things are going to play out over the long term. And that's causing market instability. It's causing investor uncertainty and so forth. So there was some movement towards this notion that if we can lock in emissions reductions in a legally certain long-term framework, you also have this benefit of increased market stability, increased investor certainty that you don't get to the same extent if you're chopping and changing policy and so forth. So a whole range of reasons there as to why there are very strong arguments as to why we need them. How effective they are, which was the second point you raised, in a sense, depends on a case-by-case analysis. One thing you'll see in the book that we've mentioned is that as you move through the deep dive national case studies, which are designed to make the issues that are raised in the more generalist international discussions and conceptual discussions, designed to make those concrete, to concretize them in specific national circumstances, you see that you have a very diverse array of experience. You see that there are things that appear to be working in some cases and not so much in others. So I mean, just to take some concrete examples, the Mexican regime, which Alina Averchenkovich treats very well, and which I discuss in a couple of chapters in some detail as well, contains, many, the Mexican Climate Change Act, many strong, useful components, makes a very useful contribution to setting a legal and policy direction for the country as well in this important area. It also contains some problematic features. For example, it contains some targets, but those targets are rolled into so-called transitory articles, a slight quirk of Mexican law, which are kind of bolted on to the end of the act, but have a separate existence from the act. They're not considered a substantive part of the binding law itself. So you see a strength in the sense that there are some target drivers there, but you see an arguable weakness in that their legal weighting is partially subverted by the way the law's structured. Then if you take, say, Denmark, this is going to the question of do they work or not. Denmark's act, its initial climate change act, it has revised it, I think it's fair to say was weak, and for evidence on that, I point to Sarah Nash's analysis in the book itself, plenty of other research on this too. And it's also proved by the point that the Danes substantially revised it with introducing a new Danish act relatively recently. That act was quite weak. Denmark is a very strong performer on renewables and things like this. In some ways, it's an envy of Europe in terms of how well it performs in certain regards in climate. So here you have some disconnect between what was a relatively weak climate change act and a very strong performance. So you get these sorts of quirks as well, and that raises problems around the question you asked as to how well they work. And then you can get some very complex governance scenarios where we might usefully take the Dutch experience as an example of this. The Dutch put a climate act in place. Great. They applied, I believe it was a 95% emissions reduction target for 2050, if I recall, and a 49% greenhouse gas emissions reduction target for 2030. It also brought in a climate agreement, which is a substantial policy document, different to legislation, different to the Climate Change Act. It laid down targets in that as well that were slightly different from the Climate Change Act. And then a case called the Urgenda case, which may be known to you, some of our listeners, a famous case. Their NGO pressure in the courts succeeded in having the courts apply a particular target, a greenhouse gas emissions target that the Dutch government was subject to. So in that scenario, to interpret the Dutch Climate Change Act and the targets that it applies, you in essence need to recognize the Climate Change Act and its targets, but also a climate agreement, which has some distinct targets. And then, you know, last year, the agenda case was a particularly important target driver as well. So you have targets emerging from the courts. So to interpret how well the Act's working, you really need to carefully think about it in concert with policy and litigation as well. So as to how well they work, how effective they are, as you ask, we take that on a case-by-case basis, I'd suggest. But in general, they are undeniably effective in locking in policy direction certainty, in locking in certain objectives, in cohering particular action. And there's plenty of evidence that points to that in the general sense, their effectiveness and their capacity to be effective.
All right, sorry. All right, thank you very much, Thomas, for that. I will just promote Ellie. I think she has a question. I'll just promote her so that she can ask it directly.
Thanks.
Millicent, would you like to ask your question directly? All right, as we're waiting for her, I know Eddie has a question. Eddie, are you there?
Yes, I am. Hello, Victoria, and thank you, Thomas. I'm quite familiar with Thomas's work, and thanks for that excellent analysis of the climate change and the book. So, I mean, my question, I was going to ask, what sort of governance structures do you think, or should I say hurdles, do you think should be overcome by jurisdictions who are, you know, trying to design a climate change act or a climate change regime? What sort of hurdles do you see for both developing and developing jurisdictions? What sort of hurdles would you consider need to be overcome in order to design a robust climate change regime? Thank you.
Thanks, Eddie.
All right. Yeah, I think, Thomas, you can answer that. And then there afterwards, Millicent, you also ask your question after Thomas has answered this first one. Thank you.
Thanks. Thank you, Eddie, for the nice comments and the interesting question. Again, Eddie, I think there's a tendency in this area to try and find a magic bullet where there's perhaps a catch-all solution that might apply generally, just like the question of what would, which I try and tackle in chapter 10 of that book, what would an optimum climate change act look like? And you tend to find you're dragged back to earth by reality and don't have a silver bullet necessarily, and partially need to take things on a case-by-case basis, informed by general understanding and general learning. And I think something similar can be said for the question you asked. So in terms of dealing with governance structures that maybe pose challenges for developing these frameworks and the sorts of hurdles they may present, one tends to need to approach that type of problem on a case-by-case basis, but at the same time, one can draw some general points based on the condition of knowledge and experience that are very important. And some of those points, I think, would point to the issue you raise of, or point to yourself, of the developed and developing world having slightly different characters in this context that would want to be acknowledged. The international legal regime tries, under the UNFCCC, Paris Agreement and so forth, to place, it tries to employ a so-called burden sharing approach where developed countries are supposed to bear the primary burden in greenhouse gas emissions mitigation. How successful that is in terms of how it's been implemented and in practice is another question. That's the endeavor. So transposing that down, if you will, to the national level, there's in a sense an implication that a national climate change act, let's say, in the developing world, would be well advised and really probably should contain some components that acknowledge the broader capacity for support there and that try and benefit from that. So again, to be a bit concrete, if you look at the Mexican Act, there are components there, and part of its overall signaling is that Mexico is open for business when it comes to international green finance. And green finance, some green finance has come into Mexico, substantial green finance, in part because the Mexican Climate Change Act has helped to structure institutions and set up processes that can absorb that finance and put it to useful purposes, solar farms being rolled out and things like this. So some of those considerations should really be acknowledged within components of an optimum climate change act. And there are certain elements on the other side of the coin that go with that, where we're looking at perhaps climate change acts in the developed world. But most particularly, there are many points, Eddie, I think that are relevant. Some in terms of hurdles, I think one substantial hurdle, to give a concrete example, that needs to be overcome to take more of a micro issue rather than a general issue, is the notion of climate change committees. Now, what they are typically advisory and reporting bodies that are set up under these acts to advise government and other actors on the emissions reduction process, on climate adaptation, and they're there to report as well on emissions reduction or finance deployment, adaptation, development, all that sort of thing. So you can imagine there may be a tendency on the part of some governments to make sure that a committee like that is within its purview of influence, if I can put it like that. So there's a question as to how independent should those committees be. The UK was quite successful in establishing a substantial independent committee called the Committee on Climate Change. If you look next door in Ireland, without going into detail, Ireland has an equivalent committee, but it's not considered to approach the level of independence that the UK committee does. That's considered by some, including me, to pose certain problems. So independence of advisory expertise and reporting expertise would be one issue. One other, I think, crucial example of a particular hurdle that can arise is when you look across the piece, if you're talking about emissions reduction targets, governments, states can tend to be quite squeamish about putting themselves in a position where a legally binding obligation may come in that will have substantial negative consequences, say, for the government if that obligation is breached. So again, to be concrete, in the UK case, we have a net zero target for 2050. That target is legally binding on UK government. It's the Secretary of State in the UK government that bears the legal burden. That person is required to secure that target. If that person doesn't, judicial review can be undertaken, so can be reviewed in the courts and found to be unlawful. There's a lot of concern and wriggling around this issue on the part of states. Again, if you look next door to Ireland from the UK, Ireland's a good example because the government just yesterday published its revised climate bill. Ireland had a relatively weak framework and trying to step it up with revisions. A big concern amongst some has been the Irish state putting itself in a position where enforceable targets may occur. New Zealand went to sort of gymnastic pains in its legislation to avoid putting the government in a position where it could be litigated against. So that's a hurdle. But what is the hurdle there? Governments and others watering down or having a tendency to try and water down aspects of legislation to sidestep accountability and enforceability. So all those sorts of hurdles add up to a picture where you can anticipate the sorts of problems that will arise, but we must concretize those in case-by-case basis, Eddie. If you look at, I'll wind up this response now, but just finally, if you look at actually, say, the Climate Change Act in Kenya, it has some weaknesses, but it's streets ahead when it comes to that issue of enforceability, because it's relatively easy for a Kenyan citizen to go into court and enforce meaningful climate mitigation and adaptation provisions. So we've also got a learning process as we look across countries and jurisdictions here, where, as I say, the Climate Change Act 2016 from Kenya provides learning opportunities in terms of what you can do with application in the Environment and Land Court there, which, speaks to how we can also overcome some of these potential hurdles and problems in a mutual learning process. So thanks for the question.
All right, thank you very much, Thomas, for that. And then I'll move on to Millicent to ask her question, and then afterwards, Jay will also ask his question.
Thank you very much. Thomas, thank you very much for this discussion. Actually, by answering Eddie's question, you have answered most of mine. because I was trying to ask you whether in your case-to-case analysis, whether you considered differential funding availability between the developed and developing countries, because in the final analysis, it will affect the overall target of climate change globally. Secondly, as an addendum to that, when we set uh, net zero targets, for instance, as you mentioned in the UK for 2050, if you don't, do you consider factoring in activities of multinational multinational companies generally, and in particular, multinational oil companies that operate, that are actually maybe UK, US, and developed countries companies? You know, they're registered companies in these countries, but they actually operate and emit the carbon pollution in developed countries. So whom do you factor, how do you address that? Because if you don't have a proper mechanism or a proper framework for addressing that, you may be jubilating that you have met net zero in the UK, whereas UK companies are emitting like mad in developing countries. So if you don't address it, we are back to square one, because climate change is global. You know, so these are the issues that perhaps, you know, if you have an answer, I don't know whether you do, I'll appreciate.
Thank you. Shall I come in there, Victoria?
Yeah.
Yes, and then there afterwards we shall have the last question from Jeff.
Sure. Yeah, thanks for that. I mean, that's a really important question. I think the insights you raised, Millicent, are very important. Yeah, I mean, that's a hard problem in the sense that what we're dealing with here are national climate change acts. They tend to have what lawyers might call a public law focus, but a public interest focus. But as you imply by your observations and question, which is quite correct, it's very difficult to govern this area effectively in the public sphere only, particularly where one realizes that the private sphere, or recognizes that private sphere plays a crucial role, and that raises all sorts of regulatory problems. And especially when you factor in the way in which the private sphere behaves, we're not just dealing with necessarily, you know, we talked about, I just mentioned Kenya, let's say, with some sort of fairly extensive private company within Kenya. We're typically dealing with very complex, well, we're often dealing with very complex multinational companies. So problems arise around the private nature of those companies, around their multinational nature. Those are hard problems. More work needs to be done on them, and it's a difficult problem that needs to be tackled in order to make our governance approaches as effective as possible. And it goes to, I think, listen, the theme of what you were raising or asking in your first point, this notion of, say, finance between developed and developing countries. Daniel Badansky, who's rightly considered a leading authority in this area, and some colleagues have characterized climate change as being planetary in scope and intergenerational in its impacts. So planetary in scope, a lesson there is when we're talking about a national act, in a sense, we have to recognize it's not just national, it's planetary, and that will engage international finance. And what I was getting at previously in response to Eddie's question is national acts need to be internationally sensitive to that finance. That raises questions as to how we structure and stream it. And we need, I would suggest, strong, profound emphasis on the needs of the developing world in the context of mitigation for a whole range of probably obvious reasons that need to be recognized in these frameworks. Multinational companies, the private sector, is a difficult problem that casts light and shade over these regimes. There's actually very good work on this by Professor Abby Brown, who's a colleague of mine at Aberdeen, and she goes through really the many ways in which power, governance power in a sense, is displaced to the private sphere in this area, posing all sorts of legal problems and challenges that need to be met. And in fact, Eddie, Dr. Waifa, who's on the call, has just done some interesting writing recently about how litigation that may appear to involve, we're talking about Nigeria, but let's say locally specific issues in Nigeria actually engages complex multinational companies in ways that raise all sorts of legal jurisdictional problems, complex court interests. So all of those problems need to be tackled, and I think they are broad systemic challenges that we need to deal with. And again, the acts need to be structured on the basis of attending to those problems where possible. They typically aren't, so improvements are needed there substantially, I would suggest.
Thank you.
All right, thank you very much, Thomas, for that. I'll move on to Jeff. Would you like to ask your question?
Hi there, thank you, Victoria. And first of all, congratulations on your new book, Thomas. I've read a bit of it so far and it's fascinating, so really enjoyable.
Thank you.
My question is, should the Climate Change Act be technology neutral? Now, I know that it's through the carbon budgets and stuff that it does direct the technology options, particularly in mitigating climate change. But overall, it is quite technology agnostic in the way it's framed and what it does. And then the second part of the question is, and how important is the role of having an independent committee on climate change to guide this? And really, I ask this because we still have these debates about CCS, gas as a transition fuel, and so on and so forth. So I was just wondering what your thoughts were on that.
Yeah, thanks, Jeff. That's an interesting question as well. Yeah, it's a good characterization, I think, to say that the Act tends to be technology neutral, as you say. I think part of the reason for that, only part though, is a systemic reason, in that I often, because we're talking here about the UK Climate Change Act particularly, I often characterize it as or encourage students and others to think of it as a bit like a skeleton regime. You have the bones that are there. The skeleton is a sort of skeletal framework. The UK regime is a kind of skeletal framework. It's a framework regime. And a question then arises as to, well, what's the flesh on the bones going to look like? That's a slightly separate question. The flesh and the bones, there's some flesh in it, but it's typically to be stimulated by the framework, to be created within its parameters through powers to issue secondary legislation that are enabled, powers to create trading schemes, powers to do X, Y, and Z if that's considered an appropriate option. And the tech components kind of operate in that basis. There's a general momentum towards, embracing technology and stimulating it where it's useful to the low carbon transition, but it's very sort of abstract, skeletal approach. What's the flesh on the bones going to look like? The Act doesn't really answer that in a concrete way. So that matter of it being tech neutral, in a sense, is an issue that actually extends to a kind of variety of climate issues if you adopt that skeleton view. Part of the reason for those sorts of approaches was when the Act was being fleshed out, it was thought that policy consensus would be easier to achieve if you had a bit more of the bones rather than the flesh, and the flesh debates could play out more actively in the political sphere. Whether or not that's the most useful approach is something that could be debated, but it does mean with tech, it has sort of light touch recognition, and tech development is playing out more in the terms of the flesh rather than the skeleton that's provided by the Act itself. Therefore, I think an argument could be made that's probably particularly important that there's an independent committee on climate change to guide those sorts of processes. The committee is a large committee. It's well resourced, has a big secretariat, kind of multi-level committees as well. There's a subcommittee dealing with adaptation and things. It has very good research capacity, resourcing. It's independent of government, and I think it doesn't have policy setting powers, but its independence, reporting capacity, and so forth is a partial way to actually hold government to account. There's a trend in the legislation where when the government departs from the Committee on Climate Change on a major issue, it needs to account for the reasons as to why it has departed from it. But there's also quite a good tradition emerging where the Committee on Climate Change, when it releases, say, a report, which could, let's say, cover tech or incorporate tech, tends to get quite good media traction, tends to get notice, and all of that steps up a pressure on government to acknowledge what the committee is recommending and makes it a little harder to depart from it. So the CCC's contribution, and as you can tell, I'm a big proponent of the independent element of the CCC. Not everybody is when it comes to these acts. I certainly am. I think there's a useful contribution that can be made there, as I say, especially when the act is what I would say or describe as relatively light touch on tech, which I think, Jeff, you probably agree, given your expertise in the area, could be a concern over time. Thanks.
Brilliant.
All right. Thank you very much, Thomas, for that. I see we've run out of time, and since we don't have any more questions, I'll let you to give us the concluding remarks with respect to National Climate Change Acts. What are your concluding remarks? What should policymakers look out for? What should institutions look out for? But also the international organizations. So what is the takeaway with respect to the implementation of National Climate Change Acts?
Well, thanks for having me. Thanks for all the very good questions. The book itself that we've been discussing demonstrates the value and utility of national climate change acts. So I would encourage them to be strongly considered by countries around the world. I'd encourage recognition of the major components that we see emerging within these acts, which are basically, and therefore inform their development, their what will be their implementation. So the major thematic components they typically deal with, they have a substantial focus on tackling mitigation and on adaptation. And with granular components, they tend to incorporate emissions reduction targets if they're well designed, so-called carbon budgets, certain technical reduction mechanism, long-term planning procedures around climate, the creation of those sorts of independent committees we talked about. There tends to be, in best practice cases, adoption of robust mitigation plans, adaptation plans, opportunities for public participation and engagement, monitoring reporting procedures. We've touched on the sticky issue of sanctioning mechanisms when we talked about enforceability. So ideally, some relatively robust sanctioning facilities, institutional transparency, and baked into the cake of all that is what Alyssum pointed to as well. A sensitivity towards green finance opportunities, and read in the context of the international sphere as well as the national sphere, given the complex world we live in. And if we can take on and break down negatives of multinational companies and so forth in this context, more the better. And I think that's actually very, very necessary as we go forward. So.
All right, thank you very much, Thomas, and thank you very much, our participants. Thank you for the brilliant questions. I note that we are live on YouTube, so if you have any colleagues who have missed the video, you can always refer the live link to them. And also for those who registered, I'll send you more information about this webinar. This marks the end of our webinar. Thank you very much and have a lovely day. Bye-bye.
Thank you.